Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is B Containers LLC vs Deputy Commissioner of Income Tax, pronounced by Delhi High Court on the 14th of May 2026. The petitioner, B Containers LLC, challenged the assessment order dated the 26th of May 2022 for assessment year 2013-14 and penalty order dated the 29th of March 2023 under Section 271(1)(c) of the Income Tax Act, 1961. The core grievance was that the assessing officer initiated reassessment proceedings under Section 148 without serving the mandatory notice on the petitioner. The petitioner specifically averred that neither the notice under Section 148 nor any subsequent communication was served, depriving it of the opportunity to file a reply or participate in the proceedings. The department, despite being represented, failed to file a reply to the writ petition. Critically, on instructions, the department conceded that it could not produce any evidence or proof of service of the Section 148 notice. This admission became the linchpin of the court's decision. The court inferred that no notice was served, rendering the entire assessment process a nullity for violating principles of natural justice. The Delhi High Court's reasoning focused exclusively on the procedural defect. The court emphasized that Section 148 requires the AO to serve a notice on the assessee before reassessing income. This notice is the jurisdictional foundation for reopening an assessment. The department's inability to produce proof of service led the court to infer that no notice was served. The court held that the absence of service of the Section 148 notice directly violated the principles of natural justice, specifically the rule, right to be heard. The petitioner was denied the chance to file a reply, present evidence, or contest the reassessment. The court cited Article 14 of the Constitution of India. Since the assessment order dated the 26th of May 2022 was founded on a defective notice, it was quashed. Consequently, the penalty order dated the 29th of March 2023 under Section 271(1)(c), which was dependent on the assessment, also fell. The court clarified that the quashing was solely on the ground of non-observance of natural justice, not on the merits of the tax liability. The court did not dismiss the reassessment altogether. Instead, it revived the Section 148 notice and directed the AO to serve a fresh copy of the notice along with the reasons for reopening to the petitioner's email ID. The AO was instructed to fix a hearing date at least 15 days after service. The court explicitly preserved the petitioner's right to raise all objections, including the objection of limitation. This is crucial because the original notice under Section 148 was dated the 30th of March 2021, and the petitioner may argue that the reassessment is time-barred. By allowing this objection, the court ensured that the petitioner is not prejudiced by the department's procedural lapse. The Delhi High Court's judgment is a resounding affirmation of procedural fairness in tax administration. By quashing the assessment and penalty orders due to non-service of the Section 148 notice, the court has sent a clear message: the department cannot bypass statutory requirements and expect its orders to stand. The decision is particularly noteworthy because the department's own admission of inability to prove service sealed its fate. The court's directive to revive the notice and proceed afresh, while preserving the petitioner's right to raise limitation objections, strikes a pragmatic balance. For tax practitioners, this case serves as a powerful precedent to challenge assessments where procedural lapses are evident. It reinforces that even in high-stakes international tax matters, the rule of law and natural justice must prevail. The judgment is a reminder that the Income Tax Act is not just a tool for revenue collection but a code that must be administered with fairness and transparency. Question: what was the main reason for the Delhi High Court quashing the assessment order? Answer: the court quashed the assessment order because the assessing officer failed to serve the notice under Section 148 of the Income Tax Act on the petitioner. The department admitted it could not produce proof of service, leading the court to infer a violation of principles of natural justice. Question: did the court decide on the merits of the tax liability or penalty? Answer: no. The court explicitly stated that it was quashing the orders solely on the ground of non-observance of natural justice. It did not examine the merits of the assessment or the penalty under Section 271(1)(c). Question: what happens to the Section 148 notice after this judgment? Answer: the court revived the Section 148 notice. The assessing officer must now serve a fresh copy of the notice along with the reasons for reopening to the petitioner's email ID and fix a hearing date at least 15 days later. Question: can the petitioner still challenge the reassessment on the ground of limitation? Answer: yes. The court expressly preserved the petitioner's right to raise all objections, including the objection of limitation. The petitioner can argue that the proceedings were barred by limitation as on the 30th of March 2021 or as per the original notice. Question: what is the significance of the department's failure to file a reply? Answer: the department did not file a reply to the writ petition. This, combined with its admission that it could not produce evidence of service, weakened its case. The court inferred that no notice was served, which was fatal to the assessment order. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.